Hi everyone, we're just going to talk briefly about attribution, citation, and sources today. First we're going to start off with attribution. I know we've probably talked a lot about providing proper attribution for the assertions that you make, and you've probably heard it over and over again, but I just want to point out some places where attribution was missing, and I noticed it across the memos is kind of a common thing. So whenever you're using another source's words or ideas, even if you're not directly quoting them, you're paraphrasing them, you need to provide a citation to attribute to that source. So quotations definitely need attribution. When you're explaining the law taken from some source, whether it be statute, regulation, or case, you'll provide attribution. When you're explaining the facts of a case, so when you're making a case comparison and you're stating the relevant facts of a similar case, then you still need to provide attribution because those facts came from somewhere. You didn't just make them up. So you'll tell the reader this is where the facts came from. You can go look and you can verify it. If you go to the source, you'll know they're true. You will provide attribution even when explaining the facts of your own case. That's not something we've done yet, but when we write a motion, we'll probably be given an affidavit or a deposition so that you can write to the judge and they know you're not just making facts about the case up, you're citing to something that supports your assertions. Generally, whenever you're using the content of another source in your own work, say you're taking the interpretation of a law from a secondary source or even a primary source, you're going to need to provide attribution. And we do this because we want to avoid plagiarism, but we also want credible support for our assertions. That's really important if you think about the purpose of the deliverable. It's going to be a guide for attorneys to help clients get gender-affirming care. If the attorneys read your assertions or your information, it might be super helpful, but if they can't go to the legal authority, then it's not going to help them in court. They can't give something without citations to the judge because it won't be binding authority. Next, we're going to talk about citation. I just took the kind of common mistakes from the memos and highlighted a couple rules. I won't go over all the rules in the blue book, but I think these ones are especially important to tab if you want to tab your blue book. So rule 1 first talks about signals and citations in general. First, it talks about how to use citations in 1.1. There are two types of citations. There's the citation clause and the citation sentence. The citation clause is used in the middle of a sentence. It's set off by commas and it starts with a lowercase letter because it's in the middle of the sentence. You would use a citation clause if you want to attribute or give attribution for your sentence, but the source doesn't support the entire sentence, it only supports the beginning. So you would use beginning of the sentence, comma, citation clause starting with a lowercase letter, comma, end of the sentence. And then if you need attribution for the end of the sentence, you would provide that in a citation sentence like usual. And the second type of citation is a citation sentence, which I think we're mostly familiar with. We write our whole sentence and we have a source that supports the entire sentence, and we separate that with a period and a capital letter. And these are the rules for in-text citations. If we do end up using footnotes instead, which we'll have to talk to Belkis about what she prefers, we can talk about how those rules differ. Rule 1.2 talks about signals and what to do when you have multiple signals. So what's important to note about using multiple signals is that there are multiple types of signals. There are signals that indicate support, which would be see or see also, or no signal at all. Your source supports your assertion. But there are other types of signals as well. There's signals that indicate a useful comparison or signals that indicate contradiction. When you're using the same type of signal, you can use them in all one citation sentence separated by commas. So see and see also, because they're the same type of signal, they both indicate support, you use a comma to separate them. But once you switch to using a different type of signal, then you're going to separate it with a period and start a new citation sentence. It's really helpful to look at the Blue Book and just see the breakdown of the types of sources, and I think it will make more sense if you do that. Another thing to note is that signals carry over within a single citation sentence. So if you use C in one citation sentence and then don't provide a signal for the next source and it's separated by a comma, it's implied that C carries over and applies to source 2 as well. So the sentence I have here, because it's all within one citation sentence, it is equivalent to the sentence on the other side of the equal sign. And Rule 1.2 is also really important because it explains what the meaning of each signal is. This is something I think you should read if you're having trouble understanding when to use C as opposed to when to use no signal. So these are kind of the common ones I have listed there, but there are multiple other signals that you can use. No signal you'll use when you have a source that directly supports your assertion. The reader can look at the source and they can look at your assertion and they can really see where you're coming from. They're not going to have to make any inferences to get from the source to your assertion. It doesn't have to be a direct quotation, but a lot of times if you have a quotation, you don't need a signal because it's very obvious that what's said in the source is equivalent to what you're saying in your assertion. When your assertion is supported by the source but not directly, the reader is going to have to make an inference to get from what the source is saying to what your assertion is. Then you'll use C. So that's the difference between no signal and C. There is some kind of inferential leap that the reader has to take. The other signals I have listed here, C also. The source provides support for your authority. Usually this would happen after you provided a case illustration for one case, comparing that case to your client's case. But you want to tell the reader there are other cases that would also provide support, and they can also direct their attention to those cases and look at them, but you're not going to go through it completely. It's useful to provide a parenthetical in that case as well, since you're not going to provide another full case illustration, but you can tell how that authority also supports your assertion. CEG is used when you have multiple authorities that support your source, and they're saying kind of the same thing. It's not necessary to cite to 10 cases that are all providing the same type of support for your assertion, so you use CEG, and it kind of tells the reader that there are other sources out there that provide additional support. But C is a different type of signal. It's used when you have an assertion, you use some sort of source that provides support, and then you're going to say to the reader that there's another source out there that says something opposite to what I just said. But see this case, which has a contradictory holding. So in that case you use but C. It's pretty helpful to use a parenthetical as well, so the reader can understand what the contradictory case held that is opposing your assertion. And Rule 1.5 talks about parentheticals. I know you were required to use a parenthetical for your memo, but I think they're generally super helpful. They can give a quotation to the authority and, kind of explain a relevant part, or it can just be an explanatory parenthetical, which can just tell the reader why you're citing this case, why does it matter, without having to go through a full case illustration. So it really saves you space, but still is very effective. What I would note about parentheticals is that when you're using a quotation in a parenthetical, you're going to format it the same way as the quotation appears in the authority. So if it has a capital letter to start with, you'll keep that capital letter. If it's an explanatory parenthetical, you always start with a lowercase letter and you use a present participle to begin the sentence, so an ing word. A lot of times you would have a sentence, use a parenthetical, say parentheses, the case held that the case held that this, whatever happened in the case. You can convert that pretty easily by just saying holding that this, explaining that this, or finding that this. Any ing word is fine, but you want to make sure you're formatting it according to what the Blue Book wants. And if you have multiple parentheticals, you'll need to cite them in the correct order according to Rule 1.5. Rule 1.3 talks about subdivisions. So 3.2a, if you're citing to multiple pages within a pin site, you only retain the last 2 digits of the pin site range. So 396 to 97 instead of retaining all 3 digits. 3.3b talks about multiple subsections. If you're citing to any type of source which has divided by section, so like a statute or a regulation, and you have multiple section symbols, you want to look at Rule 3.3b. When you're citing to one section, use one section symbol. So that's pretty easy, like 335 USC 101, one section, use one symbol. Even when you have multiple subsections, but you're still only citing to one section, then you're going to use one section symbol. So it's still just one section. Even though we have multiple subsections A and B, we use one. Once you start to cite to multiple sections, 112 to 113, then you're going to use 2 section symbols. Rule 4 talks about id. It's very important to understand that id can only be used when the preceding citation only contains one authority. If you have a citation that contains 3 cases, and then you use id, the reader's not going to know which citation or which case id refers to, so it's not going to be very helpful, and you won't have proper attribution. Id is always underlined or italicized depending on the style of legal writing. Whichever style you're using, the period is going to be in the same typeface, so it's either going to be underlined or italicized as well. So the period will never be in regular typeface. And when you're using id and you're referring to a different page, but referring to the same source still, you can just use a pinned cite. For pages, you would use at. For sections, you don't use at because at will never precede a section symbol. And to make sure that the reader understands what source you're referring to when you use id, you don't want to use id as the first citation on the page. After the page break, you want to make sure you either have a full cite or a short cite before using id. Rule 6 talks about a lot of small kind of technical things. 6.1a talks about spacing. So single capitals, which would be like F or S, just single letters, will be closed up, no spaces. However, if you have a longer abbreviation, it will be surrounded by spaces, so SUP or CAL. There's multiple letters there, it's a longer abbreviation. But we do treat ordinals like 2D or 3D as single capitals, so those will be closed up as well. That's why we have F space SUP space 2D, because SUP is a longer abbreviation, but we close up F2D because it's a single capital and an ordinal, and they should be closed up. The same rule applies to court abbreviations. SDNY, they're all single capitals, so they're closed up, but ND-CAL, because CAL is a longer abbreviation, there's a space. And 6.2b just says that ordinals should not be in superscript. So if you're citing to a circuit court, the TH in 6 should be in normal typeface, not in superscript. Rule 10 is a very big and important rule. It's for cases, so I just listed here elements of a case citation. So these are all the elements you're going to need. You don't have to add any more elements, and you shouldn't leave any elements out. And I think you're probably pretty familiar with the elements by now, but you can look at Rule 10. 10.2 talks about case names. So case names are always underlined or italicized or in regular typeface. That will just depend on the type of legal writing that you're doing. If you're referring to a case in text, so you want to explain in a sentence what the case said. So in Vargas, this happened. You're going to use the same typeface for the case name. So you'll underline it. You don't have to provide the full citation there. You'll provide it at the end of the sentence. You need to abbreviate case names according to the T tables. So a lot of times you're going to have words like hospital or company or incorporated that are abbreviated according to what the T tables say. Most of the time you're going to eliminate procedural phrases from the case name. Other times you're going to abbreviate them. So check 10.2.1b to determine what you're going to do with those procedural phrases. I know a lot of people cited to the Vargas case, which I've been through. The Blue Book tells us in that rule to use XREL instead. So that's what we do to get a proper citation. Rule 10.3 talks about reporters. Sometimes the case will appear in multiple reporters. That happens a lot, but that doesn't mean we're going to cite to every single reporter that the case appears in. That's just going to waste space and it really doesn't add much. So the Blue Book actually has preferred reporters for each case. If it knows that it appears in both the mass reporter and the any reporter, the Blue Book is going to tell you which to cite to. So use T1 to check and see what reporter to cite to. There's no need to parallel cite to both of them. And then again, you're going to space the reporter abbreviation according to 6.1a. Rule 10.4 talks about court and jurisdiction. So the court needs to be indicated when it's not apparent from the reporter which court decided the case. If you're citing to a reporter like the U.S. reporter, then it is apparent which court decided the case because the U.S. reporter only publishes cases decided by the United States Supreme Court. So it's really not going to add anything to indicate U.S. Supreme Court in the parentheses before the year. However, a lot of reporters report cases from all over the place. So the New England reporter and the federal reporter don't make it clear what case or what court decided the case. So you're going to need to indicate that in the parentheses. Again, use the T tables for abbreviations. If you're going to abbreviate the court names like Middle District or Southern District of New York, it'll tell you exactly how to do that. And don't use superscript for ordinals if you're citing to a circuit court. Rule 10.8.1 tells us about pending and unreported cases. I know these are kind of tricky, but if you look at the rule, it'll tell you exactly the elements you need to include. So just follow the rule, include all these elements, don't miss any, and don't add extra elements because you don't need them. So have the case name like usual, then we have the docket number. A lot of people forgot to put the docket number in, but it's important because it gives the reader assistance in finding the case if they want to look up the actual case. And it's going to be the same no matter what database you look up the case in. So if you use Lexis or Westlaw, it's still going to be the same docket number. And then after the docket number, you include a database identifier. That's kind of like the reporter for the legal database. So Westlaw will have its own database identifier. Lexis has its own. So that's also going to help the reader identify how to find the case. And I would recommend that the LO decides which database identifier they're going to use. So keeping it consistent, you'll use either all Westlaw identifiers or all Lexis identifiers. That's just a decision you can come to at a later time, but it's good to keep it consistent. And then next you're going to have the pin site. So it's a little different because you're going to have a asterisk and the court as usual, but the date is going to be the full date, so the month, day, and year. And you'll abbreviate the months according to T12. If you want to provide a short form, you can do that as well. That's Rule 10.9. So 10.9 governs short forms. You would only use a short form after you've given the full citation. So it's very important not to use the short form until the full citation has been given. That's something you can miss pretty easy, but it's important because the short form can sometimes make it difficult to find the case. You might need the full citation to find the case that you're referring to. There are multiple ways that you can give a short cite. all of the forms are acceptable, but some are easier than others. So the third example I have here, it's an acceptable short form, but a lot of people wouldn't know by looking at the reporter and the volume and the pin site what case I'm referring to. But if I provide the first or one of the parties' names, it's a lot easier. So some are easier than others, but they're both acceptable. And what I would just recommend is that you choose a consistent form of short cites. Rule 12 talks about statutes, and you should be pretty familiar with that because you all cited to the EMTALA statute. You have the elements here listed in Rule 12, the title, number, USC, abbreviated USC, not United States Code written out or anything like that. Section symbol, multiple section symbols if you have multiple sections, and then the section number and the year. Some of these things we talked about before. One thing to note is we want to cite to the official code, the USC, not the US Code annotated or the US Code service. I know that's what Westlaw and Lexis give us, and that's probably where we looked up the statute anyway. But if it appears in the official version of the US Code, we cite to the official version of the US Code. The only exception would be if the information we're citing does not appear in the USC. If it's something specifically in an annotation maybe that Westlaw gave, then we'll cite to the USCA. And the year we cite is going to be the year of the last codification of the code. So the code was codified in 2012. And it's codified every 6 years, so 2018 it will be codified again. We'll always cite to the last year of codification. The only exception would be if we're citing to information that does not appear in that edition. So if you're citing to EMTALA and it's been amended in 2014 maybe, the information we want to cite to is only in the updated version, then we have to cite to 2014. Or maybe we want to cite to an old version of the statute, maybe a 1998 version, and it doesn't appear in the 2012 version, then we're going to cite to the older version, but otherwise use the last year that it was codified. Some other rules to flag would be Rule 14. That's going to talk about administrative and executive materials. If you need to cite to the Code of Federal Regulations or a Federal Register notice, Rule 14 will give you the elements that are necessary there. Rule 15 and 16, pretty similar, non-periodic and periodical materials. So if you have books, reports, law reviews, newspapers, 15 and 16 will cover it. 18 is internet and electronic resources. Those can be tricky, but I'm sure you'll come across them a lot. If you have something like a web page or even like a sound recording, Rule 18 is going to cover that. And don't forget to use the T-tables. They provide abbreviations for case names in courts and other abbreviations. They also provide information on how to cite non-federal sources because the white pages mostly just tell you how to cite the federal version of a statute. But a lot of states will have a slightly different method, like New York or Massachusetts might cite their statutes a little bit differently, so look to T1 to determine exactly how to do that. And then again, T1 also lists the preferred reporters if you have multiple reporters that the case appears in and you're not sure which one to use in your citation. What I imagine for the deliverable is that you'll probably form a citation committee that will look over all your citations before the final draft, but I do recommend, even though you're going to have that double check, to try your best to do Blue Book citations now, because it's not going to be fun to leave all that for the citation committee later. If you have questions, you can go to the law librarians on the 3rd floor of the library. They are super helpful and they're experts in Blue Booking, but it's going to get really busy around the time every LO is submitting their final draft. So if you can go to them in advance, that's always a good idea. Another thing you can do is make a list of the common citations that are tricky. So maybe in the deliverable you're citing pretty often to a fact sheet or a web page and you're not really sure how to do it, but it's going to come up a lot. we can make a list, and the LFs and the Blue Booking Committee and the law librarians can look at that. So here I just have a citation for you to revise. I put a lot of the common errors that I saw in the memos here, and this is just to confirm that you watched this presentation, and I'd like you to email me my email address here with your answers by Friday the 5th at 8:30. It doesn't really matter to me if you get it exactly correct. What just matters to me is that you email me at all to tell me that you watched this. And lastly, just to talk a little bit about sources, what I've seen from the deliverable is you have a lot of information that's useful from secondary sources. The secondary sources probably explain the information really in an easy to digest way, but it's really important for us to be also citing to primary sources, because primary sources are what's going to be binding on the courts. So attorneys will not be able to use secondary sources to get courts to rule the way that they want. What we can do is take the secondary sources that we get information from and see what references they're citing, and go to those references, and hopefully we can get primary binding authority from that. Secondary sources are useful, but they're more like a starting point, and they're never going to be binding, so they're ultimately not as helpful to attorneys. We can always provide a parallel citation to both a secondary and primary source, but it's most important that we have the primary source at least. And that's all I have, so enjoy the rest of your snow day.